an application and appeal in the matter of Standish and Standish, part heard.
Yes, Mr Bishop.
Good morning. My lady, I'm turning now to deal with another criticism that's made of the judge as to the assertion that there was a failure to respect autonomy. We agree with the observations made by Lord Justice Phillips yesterday that, in a sense, every set of facts may be said to reflect the autonomous arrangements of the parties, but that doesn't ordinarily, of course, stop the court from exercising its discretion to reorder in order to achieve justice. There was no agreement in this case at all as to what should happen to the parties' wealth on divorce. Radmacher deals with divorce agreements. If there is a formal agreement as to how wealth will be divided on divorce, that is the context of Lord Phillips' comments about autonomy. But here there was no agreement of any sort about what should happen on divorce. And therefore the standard principles of English law apply. That is to say, the sharing principle, key consideration, quantification of the fruits of the partnership generated by the parties' common endeavour. Nor was there, my lady, any agreement that the parties would share or pool their assets during the marriage. In fact, quite the reverse. It was found that the wife's claims that the 2017 transfers were part of a pooling sharing marriage were untrue. Can I ask you to turn in the bundle to page 130? In paragraph 68, Mr Justice Moor considered one passage of the evidence. Towards the bottom of that paragraph, she was then asked about changing her will to exclude him in early 2019. Given the husband had transferred the best part of 80 million to her only 2 years earlier, I do consider this was a very mean-spirited thing to do. Made worse by not telling him. Mr Bishop, not unreasonably, asked her why she would not leave him half if this was indeed a partnership marriage where everything was shared. Her completely lame response was that the husband would have contested it in any case, so there was no point. I find that this action was completely inconsistent with her oral evidence, repeated on a number of occasions, that it was a partnership marriage from the very outset, built on love and trust. And then he goes on in over the page at paragraph 73. I now turn to consider how all of this should be factored into the outcome of this case. The first thing that I need to deal with is the wife's contention that this was a partnership marriage. I reject that suggestion as having no basis in fact or law. This marriage was an entirely conventional second marriage in which the husband brought significant assets to the marriage. The absence of a prenup is not significant. We know from Sharp that the failure to enter into a prenuptial agreement is not evidence of an intention to share. If this marriage had broken down 6 months after it had been celebrated, this court would undoubtedly have dealt with it on the basis of needs, albeit with additional consideration for what the wife had lost in terms of entering the marriage. She could not possibly have mounted a claim to share equally in the husband's premarital wealth. Indeed, I'm clear that this remained the position immediately before the transfers to her in early 2017. And indeed, if you go back to 130, paragraph 68, middle of the page. She told me she did not like the lady from the trustees they selected for Carter, but I do not consider that makes any difference. She did concede that the transfers to her were pursuant to estate and trust planning. She further accepted that this was the reason why the money went into her sole name and not into joint names. So there was no general agreement during this marriage about pooling. And there was no agreement in relation to what would happen on a divorce. And so we say, well, in what sense is this wife saying that the autonomy of the parties was offended in what the judge did? It simply doesn't have any validity. Indeed, the wife herself isn't contending that the prevailing arrangements at the end of the marriage should be upheld by the court, rather that there should have been an equalisation pursuant to her concession. As my Lady Justice King clarified with my learned friend yesterday, the autonomy being asserted is in relation to the autonomy of the wife's concession rather than any other autonomy. The wife's concession, as she calls it, that there should be 50-50, this was something that was never agreed between the parties during the marriage and never agreed to be applicable in relation to divorce. And therefore we say that this autonomy argument, incanted as if it's a word that gives great substance and validity to the argument, really is no more than just a rehash of the submission that title was significant. As we looked at very extensively yesterday, we say that that demonstrably is not the case as a matter of law.
Can I go back to 73, when the judge rejects the concept of partnership marriage as a matter of law? I'm not sure it's anything I've come across. Is there such a thing as are there any cases that refer to a partnership marriage?
My understanding of what he's saying there is that this was not the sort of marriage where there was a agreement that everything would be shared between them during the marriage or on divorce. Whether that's right to describe that as a partnership marriage in fact and law, whether that's a inaccurate description, I don't know.
Are there any cases in which this has been, you know, this is a partnership marriage or this isn't a partnership marriage? I'm just not aware of it, as I say, as a concept.
And it doesn't matter either, because it doesn't affect the task of quantifying the fruits of the marriage. If it was a partnership marriage or a non-partnership marriage, it's still the same exercise, which is quantifying what was generated during the marriage by the parties' common endeavour. How the parties arranged things within such a marriage, whether it was done on the basis of expressly accepting partnership or elsewhere, we say is completely irrelevant to the court's task.
I mean, we are guilty in the financial remedy word of adopting various terms of art, which in turn bewilder our colleagues that aren't part of it. But partnership marriage is not a term of art with which I'm personally familiar.
No, and I don't think it would be very welcome to introduce it. Likewise, if I can just diverge for a moment, the term separate property. Separate property in this case has been used in three different senses by my learned friend. Used as a synonym for non-matrimonial property, used as property that's in the sole legal and beneficial ownership of someone, and also used in the, sorry to use shorthand, but the para 153 of Miller sense, i.e. something that has become a unilateral asset, that is something that doesn't have to be shared in the context of a short dual career childless marriage. But we respectfully submit that separate property, the reintroduction of that word, just doesn't help. The terms matrimonial and non-matrimonial property have come to be used commonly and are an aid to the process. We stress again that it's not the labels that matter, it's the question of the endeavour and the question of the process of quantifying the fruits of the marriage. But I agree with your ladyship wholeheartedly that introducing this was a partnership marriage, this wasn't a partnership marriage. This was separate property, this wasn't separate property. Separate property versus non-matrimonial. This is where confusion lies, and it doesn't need to. I turn to the question of matrimonialization, and I do apologise for the ugliness of the term, but it's come to be used within the financial remedies argot. And what this means is that very occasionally, the court will deem an asset which is not the financial fruit of the party's common endeavour, nevertheless to be matrimonial property.
Sorry, can you go a bit more slowly? Very, very occasionally the court will deem an asset which is not the fruits of the
financial fruit of the party's common endeavours, nevertheless to be matrimonial property. So matrimonial
Can I put it in a slightly different way? Very occasionally the court will deem an asset which is not the fruits of the party's common endeavour to be rather than to be matrimonial. Sorry, I can't even read my own writing. I mean, I've just written it. common endeavour, nevertheless to be treated. What did you go? Wait a minute.
as matrimonial
Sorry,
property.
there we go.
Because matrimonial property is the fruit of the parties' common endeavour. And
Well,
you
another
have
way
some.
of putting it is to be subject to the sharing principle, because that's the underlying
I don't dispute with that
principle.
at all.
Yeah.
And I'm not.
I mean, that's the key, isn't it?
That is the key. Absolutely right. But
Is that very occasional in relation to the matrimonial home?
well, yes, matrimonial homes are seen in a different class, and that comes, my lord, from those observations of Lord Phillips that we looked at quite quickly yesterday, and we can go back and have a look at them again. So matrimonial homes, I mean, Lord Phillips says matrimonial homes often have such a place in the heart of a marriage that it seems unnatural not to include them within the sharing exercise, even if they're in one party's name, or even if they've been bought by one or other of the parties from their premarital resources. Although, as I'll come on to develop in a moment or two, it's perfectly clear that it's legitimate for the courts to say, well, we're not, even though it's within the sharing principle, we're not going to share it equally, because we're still going to pay regard to source. And I'm going to look at those cases in just a moment. But, oh, sorry, I think I said Lord Phillips at one stage. I didn't
You
mean
did.
to.
You didn't mean Lord
I
Phillips.
mean
so-
Lord Nichols, of course.
No, you were talking about K&L.
But can I start with this proposition, and that is that matrimonialisation, or this, as it were, fictionalised treatment of non-matrimonial property as if it were matrimonial, has to be done conservatively. It has to be done very cautiously, because it constitutes a derogation from the key concept, which is the court is focused on the fruits of the partnership and dividing those, and not dividing the other fruits, the other property. If too liberal or an inclusive attitude is taken to matrimonialisation, then the very foundations of the sharing principle are undermined, because what then happens is it's just the sharing principle, not of the fruits of the partnership, not of the product of the parties' common endeavour, but everything. And that dishonours exactly all the distinctions that are made going from White through Miller and recognised in this court time and time again in the leading cases. And indeed we say that the courts have got it right in terms of a conservative approach. Because if you look at the leading case of K&L, the categories identified by Lord Justice Wilson, which we'll look at in just a second, are circumscribed. And I'm not suggesting that he said that that is an absolutely exclusive list, but it's clear that it's a short list, and one which hasn't been added to by jurisprudence in the 12 years since K&L. Would you turn with me kindly to page 220 of the authorities bundle?
$212.
220, my lady,
Oh, 200.
which should be page 739 of the K&L
Yep.
decision.
Rather surprised when I turned up Jones.
Sorry.
No.
220.
Thank you.
Starting at paragraph 17, the answer to the question, and the question is whether or not over time the significance of source will diminish. The answer to the question, or anyway Lord Nichols' answer to the question, is made clear in his speech in Miller as follows: non-matrimonial property represents a contribution made to the marriage by one of the parties. Sometimes as the years pass, the weight fairly to be attributed to the contribution will diminish. Sometimes it will not. After many years of marriage, the continuing weight to be attributed to modest savings introduced by one party at the outset of the marriage may well be different from the weight attributable to a valuable heirloom intended to be retained in specie. Thus, with respect to Lady Hale, I believe that the true proposition is that the importance of the source of the assets may diminish over time. Three situations come to mind. A, over time, matrimonial property of such value has been acquired as to diminish the significance of the initial contribution by one spouse of non-matrimonial property, introducing something small. B, over time, the non-matrimonial property initially contributed has been mixed with the matrimonial property in circumstances in which the contributor may be said to have accepted that it should be treated as matrimonial property, or in which, at any rate, the task of identifying its current value is too difficult. And C, the contributor of non-matrimonial property has chosen to invest it in the purchase of a matrimonial home, which, although vested in his or her sole name, has, as in most cases one would expect, come over time to be treated by the parties as a central item of matrimonial property. So those are the three situations of matrimonialization that are identified in KNL. And we say that that is a proper sort of way to approach this issue because it is duly conservative. If matrimonialization has taken place, though, it does not mean that that property that has been placed in the matrimonial category will automatically be divided equally. Certainly not. Could you go with me, please, to back in the authorities bundle?
Can we just go back to B? Over time, the non-matrimonial property initially contributed to be mixed with matrimonial property in circumstances in which the contributor may be said to have accepted it should be treated as matrimonial property. That's quite a broad. That could be said to be quite a broad concept, a sort of broad example in just mixed.
I'm going. Well, there are two aspects to that. I'm going to develop this because we say that that test, which Mr Justice Moor should have applied in this case, was not in fact satisfied on the facts of this case. And so I'll be addressing what the elements of 18B are in a moment or two. I'm certainly not overlooking that.
No, okay, thank you.
But just to trail, it would seem there that you need to have, to use criminal parlance, an actus reus of mixing and a mens rea of acceptance that this now should be treated as matrimonial property. We say in this case, properly analysed, actually neither was satisfied, but I'll come to that in a moment. But my lord, can I just take you back to Miller? And I'm sorry that this is to revisit something that we looked at quite extensively yesterday on page 18 of the authority bundle. And it's paragraph 16 at the top of page 18. When their partnership ends, each is entitled to an equal share of the assets of the partnership, unless there is good reason to the contrary. Fairness requires no less, but I emphasise the qualifying phrase, unless there is good reason to the contrary. And as one knows, over on page 20, when Lord Nichols is dealing with how you go about the task of differentiating between matrimonial and non-matrimonial property, he puts the whole thing under a heading flexibility and makes it perfectly clear that the judge is going to undertake that task. Sometimes it's easy to do that with a sharp dividing line. Sometimes it's going to be more nuanced and more holistic. But we say if assets exceptionally have gone from non-matrimonial or are treated as matrimonial by virtue of coming within one of the KNL identified classes, let's say, nevertheless, source, provenance, the fact that it is non-matrimonial property can still be a good reason for its unequal division. And my lord, we say that that is entirely in line with what my Lord Justice Moylan said in Hart, if you kindly go to 272, paragraph 94, if, however, at the other end of the spectrum, that's the other end to a clear dividing line, there is a complicated continuum, it would be neither proportionate nor feasible to seek to determine a clear line. C&C was an example of such a case. In those circumstances, the court will undertake a broad evidential assessment and leave the specific determination of how the parties' wealth should be divided to the next stage. The third and final stage is the Section 5 discretionary exercise. Even if the court has made factual demarcation as to the extent of the parties' wealth, which is matrimonial property, and that which is not, the court still has to fit that determination to the exercise of the discretion, having regard to all the relevant factors in the case. This is not to suggest that by application of the sharing principle, the court will share non-matrimonial property, but the court has an obligation to determine that its proposed award is a fair outcome, having regard to all factors. And then critically 96, if the court has not been able to make a specific factual demarcation, but has come to the conclusion that the parties' wealth includes an element of non-matrimonial property, the court will also have to fit this into the determination, into the Section 25 discretionary exercise. The court will have to decide, adopting Lord Justice Wilson's formulation, the broad approach in the Jones case, what award of such lesser percentage than 50% makes fair allowance for the parties' wealth in part comprising or reflecting the product of non-matrimonial endeavour. In arriving at this determination, the court doesn't have to apply any particular mathematical or other specific methodology. The court has a broad discretion as to how to arrive at a fair division and can simply apply a broad assessment at the division, which would affect overall fairness, which would, I think, affect overall fairness.
The first one is.
This accords with what Lord Nichols says in my view, the decision of Jones. And therefore, if an asset has been matrimonialized, that's still its non-matrimonial source can be a good reason per Lord Nichols, and it can be something that within the consideration of the complicated continuum still requires fair allowance per Lord Justice Moylan in Hart. Can we now look at two cases where this has been put into practice? Would you turn please to in the Authorities Bundle 2, 389 and the case of FB and PS. Beg your pardon. That starts at 376. If we go to 389, sorry, and paragraph 78.
Sorry, 389.
389, is that should be page 711 of FB and PS. The principle is identified by Mr Justice Moor in paragraph 78. I remind myself that just because an asset is matrimonial property, it does not automatically lead to equal sharing of that asset. Paragraph 152 of Miller, Baroness Hale of Richmond referred to this, saying the source of the asset may be taken into consideration, but its importance will diminish over time. Mostyn J referred to this at paragraph 9 of his judgment in S and AG, where he said that even the matrimonial home is not necessarily divided equally. Under the sharing principle, an unequal division may be justified if unequal contributions to its acquisition can be demonstrated. And then on, please, to paragraphs 398, paragraph 120. AR, that was the name of the house, was therefore the matrimonial home for some 15 years. Given the dicta of Lord Nichols of Birkenhead, I can only find that it is matrimonial property. But I do not accept that this means that it is to be shared between the parties. Sorry, does not accept that this is to be shared between the parties. AR was not acquired by the parties themselves during the marriage. It had been a matrimonial home of TS and his wife since 1982. The husband and his siblings were brought up there. The transfer itself is a very significant unmatched contribution, now worth some £3.5 million gross. And then there's some consideration of the works that were done. And then over the page at 399, paragraph 124, the question then is whether I simply deduct the entire value of AR before I undertake the sharing exercise. The wife makes 2 points, and it's fact specific. 125. There are, of course, 2 ways in which a court can approach the matter. The first is to allow a discount to equal sharing to reflect the unmatched contribution. The second is to remove an appropriate share of the value of AR from the matrimonial home to reflect the unmatched contribution, and then divide the figure that's left equally. I propose to approach the matter on the second basis, and then I check it by undertaking the first exercise. I'm satisfied it would be wrong for me to allow sharing the full 1.4 million lost. I've decided an appropriate way to mark this fact that AR is matrimonial is to include the sum of £500,000, so 3 million excluded. This means that I will remove 2.912 million from the schedule. This is the value, and then he goes on to say, I assess the assets being worth 19 million. If 2.9 million is reduced, the assets go down to 16 million, and that's divided, giving each party 8 million. That's paragraph 127. And then would you go to S and AG? My Lord Justice Phillips was asking about national lottery winnings. That's something that is a feature of this case. And at page 338. The principle is stated at page 338 paragraph 8. While matrimonial property will normally be divided equally, this is not an invariable rule. The reason for this is that sometimes the matrimonial property in question will not be the product of the endeavours of the parties within the social economic partnership that is marriage. As Guestjay described in the Australian case of Farmer and Bramley, sometimes one party brings into assets which become part of the economic life of the marriage, converted, sustained and enjoyed. This is the concept of mingling referred by me in N and F. And then where I cited the remarks of Lord Nichols in Miller and Lord Justice Wilson in K and L. But even if there has been much mingling, the original non-matrimonial source of money often demands reflection in the award. Thus in S&S, non-matrimonial property, Mr Justice Burton divided the matrimonial property 60-40 to reflect this factor. In Miller, Lord Nichols specified that the matrimonial home should always be designated matrimonial property, whatever its source. He stated at paragraph 22, the parties' matrimonial home, even if it were brought into the marriage at the outset of the parties, normally has a central place in any marriage, so it should normally be treated as matrimonial property for this purpose. This is reflecting the remarks of Wilson, LJ and K&L at paragraph 18. But even the matrimonial home is not necessarily divided equally under the sharing principle. An unequal division may be justified if unequal contributions to its acquisition can be demonstrated. In Vaughan and Vaughan, Lord Justice Wilson stated, such would be the award, notwithstanding that the home had been owned by the husband free of mortgage since well before the marriage, and that, putting to one side his misconduct in dissipating assets, following the breakdown of the marriage, the effect of which is intended to be rectified by the calculation, the contribution of each party to the wealth of the family during the marriage were in effect agreed to have been equal in value, albeit not in kind. Although in the words of Baroness Hale, the importance of the source of the asset will diminish over time, I consider that the husband, prior ownership of the home, carried somewhat greater significance than either the district judge or the circuit judge appears to have ascribed it. And then what happens in S and AG on the basis that there was seen to be the introduction of non-matrimonial property that went into the acquisition of the home, we see at paragraph 37 on page 346. Given that the source of the matrimonial property was not a joint endeavour, but rather non-matrimonial property of W's.
Sorry, wait a minute. What paragraph?
Paragraph 37, my lord, on page 346, sorry.
Thank you.
This is what he does in that case. Given that the source of this matrimonial property was not joint endeavour, but rather non-matrimonial property of W's, and given the relatively short period that the husband actually lived in 108A, I do not believe that H is entitled to an equal sharing of it or anything like it. I judge that a sharing of 15 to 20% would be fair. The value of the property after costs of sale is £480,000. My assessment of the application of the sharing principle gives a range of £72,000 to £96,000. And as we saw, unequal division of matrimonial property was approved in Vaughan. It took place in Gallagher and Lawrence as well, a case I was involved in this court many years ago, and also there's reference to S&S. And so there are numerous examples of Lord Nichol's good reason, Lord Justice Moylan's fair allowance, taking place in relation to matrimonialised property. The wife in her submissions yesterday, my own friend's submissions, came close to saying, well, if it has the label matrimonial property, that must carry with it an equal division. We say that that's quite wrong. The process is not as blunt as that, but rather it is equal division unless there's good reason why not, and the good reason can be source, or, as Lord Justice Moylan put it, there should be fair allowance made. I'll come on to what might have been a fair allowance in this case in due course. My own friend refers to Jones and Jones and says, oh, well, look, the matrimonial property there was divided equally. But that was only because there'd already been a process whereby the non-matrimonial property had been completely removed, 1/3 of it. He refers to Work and Grey, another case that came before this court. That was a case where there was no non-matrimonial property. Every single thing had been earned during the marriage because they both started with nothing. Now, if we look at matrimonialisation in respect to this case, moving on from the principles, we say, first of all, the wife simply can't make up her mind about whether or not there has been matrimonialisation or not. Would you go with me, please, to the supplemental bundle, page 295.
Did you say 295?
295.
Thank you.
You'll see that the very first lines of the wife's opening position statement before Mr Justice Moor was this. This ought to be a reasonably straightforward case of 50-50 divide. There can be no doubt that the funds have been mixed and mingled and are now matrimonial. But by the time they were closing, we go on to 330. The position has changed. And what is said there at 5B, before Mr Justice Moor, is at 5B, it is not matrimonial property until the wife brings it into the partnership. And before this court, My own friends have gone further and said at times that matrimonialisation itself is something that should be removed from the lexicon. That is what's said in page 61 of paragraph 52 of the core bundle, that is.
So is that skeleton argument?
Finish with the supplementary. Back to the core. More generally, we say there is a danger lurking at the very concept of matrimonialisation.
So what paragraph are we on?
52, right at the bottom of page 61.
Thank you.
More generally, we would say there is a danger lurking in the very concept of matrimonialisation and would invite this court to remove it from the lexicon of the law of financial remedies. And also, if you go to page 54, paragraph 29, middle of the page, where non-matrimonial assets are mingled with matrimonial, then the assets are simply part matrimonial and not matrimonial. The matrimonial part should be divided equally. The non-matrimonial part then is reflected to keep the war. Here the assets were all, sorry, no, I beg your pardon, it's just above that. Sorry, I beg your pardon. It's about 10 lines down. We question whether the concept of matrimonialisation is helpful in these cases at all. We find this a very surprising proposition for the wife to be making, because other than by matrimonialisation, how does she hope to share in this wealth, which had nothing to do with her endeavour?
Well, it's, as it's been put yesterday, it's by virtue of her concession.
By virtue,
I mean, the wife's case is very clear, I think, Mr. Bishop. This is her money.
title, yeah.
No,
Yeah.
she's well, it was gifted to her. It's non-matrimonial now in her hands because of the gift.
Yeah, okay.
But she's
Well,
willing to make a concession that she would choose autonomously to share equally.
Yeah.
And therefore it is out with the concept of matrimonialization, whatever that
I
may be.
think I've dealt with.
I think that's how it's put.
I think I've dealt with all that in the submissions I made yesterday, and so
Yes,
won't,
yes,
go,
you have.
won't go over that
But I
ground again.
just want to be
No,
clear
no,
that
okay. In which case, I went too far in my submissions then, for which apologies.
Do you think it's a helpful concept or not?
My lord, I believe that it should be restricted to the matrimonial home, because I think that anything else undermines the central message of Miller and introduces undesirable complications for judges exercising their discretion. Too much confusion in terms of parties being advised by their advisors and judges having to deal with this case consistently. That would be for this court to consider as a matter of principle. But my primary submission is that it should be constrained, whether in the way, whether K&L is enough by way of a constriction. Your Lordship, my Lord Mr Justice Moylan, Lord Justice Moylan said, oh, well, paragraph 18b might on one view be quite broad. Well, that's a sort of danger flag. It's a red flag, I would say, because if you take a broad and inclusive approach to 18b, saying, yeah, it's been mixed and there's a general acceptance, then you end up with a situation whereby the central message, dividing the fruits of the partnership, is undermined. Yeah. What does the husband say about matrimonialisation? Well, we say three things. In support of my contention that when properly analysed, there wasn't matrimonialisation. in relation to the 80 million, or indeed the Ardenside business shares, when the transactions took place in 2017. And the first thing we say is that the basis upon which Mr Justice Moor found there to be matrimonialisation was a flawed basis. If we can look, please, in the judgment at paragraph 75, which is on page 132. As the 80 million transferred to the wife did not become her separate asset, in the sense that her not matrimonial property, I must decide what it did become. Mr Bishop urges me to find that it did not become marital property. He cannot be right about that. The assets are not held by the wife on trust for the husband, as he had to give up all interest in them for the tax saving scheme to work. The only possibility is that they became matrimonial property. I am, however, equally clear that this does not mean that the matrimonial property is automatically shared equally. What Mr Justice Moor does there, and that it's fair to say, and I don't mean to be too critical of the judge, that's his entire analysis of matrimonialisation, those 5 lines. Because they have been transferred to the wife, and because she wasn't holding them on trust for the husband, that's matrimonialisation. Well, we say that that is completely wrong. And it's a strange mistake for the judge to have made, because in the very preceding sentence, he rightly says that title isn't important, but simply a transfer and altering title. We say that that was an inadequate treatment of this question. And it took into account an irrelevant matter, that is title, but failed to take into account relevant matters, which is guidance from the Court of Appeal that was actually binding on him. So that's the first point, that he determined it by reference to title, matrimonialisation, and he was wrong to do so. The second point is this: if these 5 lines constitute some sort of very attenuated attempt to go through the exercise in 18b of K&L, then we say that the application was flawed on the facts of this case. Going back to 18b, we'll remember that the components are that there has to have been mixing with matrimonial funds, and there has to have been an acceptance by my client that it should be treated as matrimonial property. Both elements are said to be necessary to be there. And looking at those 2 elements, was there mixing? These assets were in, very broadly, the same form between 2004 and 2017. This was all set out to the judge very clearly in our closing submissions. If you go to supplementary bundle 308, page 318 to 319.
Sorry, could you give me
318 and 319 will all. So, paragraph 9, bottom of the page, H's pre-mat always been completely ring-fenced in his sole ownership until March 2017. And then 10, very little activity during the marriage in respect of his pre-mat assets. H is a banker, not a trader. His evidence was he purchased shares which he thought had good prospects and retained them. Ardenside was retained. The UBS accounts and UBS shares were worth 28.6 million in June 2012, now worth 34.5. In 2004, he had shares in Australian companies or held by Australian entities or within his Australian superannuation fund. Some of these were delisted. Those which remain are held within the Crestone portfolio, now worth 25 million. At least 16 million of the value comprise holdings that he held back in 2004. We give them names there. The only real change is that the premarital cash has been replaced by Silvertown, Stripe and Dial, 15 million. But like in Robertson and in Vestige, simply moving the pre-mat from pot A to pot B, still not much money. Still not much money. These assets have not made much money in a long term, in line with H's buy and hold approach to investing. And then I talk about passive growth, which I'll come to in a moment. So there was a very static portfolio of assets that was kept in largely the same format, in the same assets throughout this marriage. And then all that happened was that they were transferred from him to her. Is that mixing? We say that the guidance to that really comes from the second part of B, where Lord Justice Milson talks about, or at any rate, in which the task of identifying its current value is too difficult, i.e. there's been churn, it's gone into this and invested in that and come out, and that's a proper mixing. There's no mixing here, it just was in account A and then went to account B. So we say that the first part of matrimonialization, the mixing, didn't in fact happen in this case. The third point I want to make is, was there acceptance by the husband that these funds should be treated as matrimonial? Again, reminding this court respectfully of the observations in 18b. Over time, the matrimonial property has been mixed with the matrimonial property in circumstances in which the contributor may be said to have accepted that it should be treated as matrimonial property. And we say that there is no evidence upon which the judge could have accepted my client, or found that my client accepted that this was now matrimonial property in the sense that the wife was going to have an equal share of it within the marriage or an equal share of it on divorce. Could you go in the authorities bundle to 352, because the way this is dealt with in S and AG, we say is helpful.
Sorry, I'm still. You have to
352, paragraphs 14 and 15. What is clear to me, at least, from those excerpts, and he's referred to parts of the evidence on the preceding page, is that the decisions that were made as to in whose name the money at any given time were held were influenced almost exclusively by the question of where interest would be most beneficially obtained. The placement of monies into his name or her name, the placement, at least on a plain reading the words, seems to have nothing to do with any underlying decisions by the parties as to whether such and such fund should be characterised as matrimonial with concomitant consequences of equal division on divorce or not. We say here the judge's findings about pooling are very important in paragraph 73. He found in plain terms that this was not a pooling, sharing marriage. And it was significant that the husband didn't put the assets into joint names.
So your primary submission, though, is that all of that can't arise anyway, because matrimonialisation can only apply to a matrimonial home.
Well, that's the submission I would make as to how this court should now confine the proposition of matrimonialisation further.
So you would say that paragraph 18 of K&L should also be confined to the matrimonial home.
Yeah, I say take out B. That would be my submission as to But I mean, I
So,
appreciate.
let me understand this. So, if parties before marriage both have a shared portfolio,
Yeah.
or portfolio, which on marriage they
In their each in their sole names.
their sole names.
Yeah.
Following the marriage, they decide to combine it for many reasons, including that they'll get better terms and better returns if they have a bigger pot in their joint names, and then they declare it for tax purposes as joint property. Is it impossible for that to have been matrimonialised?
I would submit, respectfully, my lord, on that scenario, it's not a difficult task. The court would see what their premarital contributions were from each side, and reflecting their premarital endeavour, and within its discretionary exercise, make allowance for the fact if they've been made in absolutely equal sums, that may be that there's no justification for any departure. But say someone had a portfolio that was worth 1 million and someone else had a portfolio worth 2 million, and then they combined it, I would say that the disparity in the premarital assets there would certainly require or reflection in the award. And there are lots
even
of
if they declared to the tax authorities and paid tax on the dividends on the basis that they were 50%.
Absolutely, my lord, because you keep going back always to the safe ground, the terra firma, which is what was generated, what was the fruit of the partnership generated by the parties' common endeavour, and what was the other property.
So there's no concept of pooling then?
Well, I think that we have to, of course, accept what's said in relation to matrimonial homes.
So it's only matrimonial homes?
Well, my lord, I don't say that that's what the current state of the law is, because I have to accept, of course, that in paragraph 18b of KNL, Lord Justice Wilson identifies another situation. I wonder whether it's time for this court to shut that down, or to express views about how useful that is. But on the basis that we're looking at what Mr Justice Moor was doing, and he was, of course, having to consider 18b, because it was binding on him and the authority was in front of him. Did he apply it properly? Was it fair to say that this was a mixture? No. Was it fair to say that this was acceptance, that this money, when it was transferred in 2017, should be matrimonial? We say absolutely not, because this wasn't that sort of marriage. And it was done for a particular purpose, not to endow her with half of it or for this to be shared equally on divorce, but for a tax plan that was never completed and that was described by the judge as monumental folly. Now, the fact that it was folly probably is neither here nor there. But was it an act that was intended to endow her with a matrimonial right of 50% in equal sharing in relation to it? We say absolutely not. And so we say that matrimonialisation, as found in this case, was a flawed exercise. And just as in JL and SL, just as in J&J, the money should have been returned to the person whose endeavour had generated it. If, however, this court regards the judge's finding of matrimonialisation as a legitimate exercise, or evaluative exercise by him, then is it right, I'll start again, was sufficient allowance made within his award for the non-marital element, in line with what was required by this court in Hart, paragraph 96. I turn to that now, very near the end. The first point is that it was undoubtedly right for the judge to identify a sharp dividing line in relation to the Ardenside land. And you will understand the significance. The Ardenside land, always preserved exactly the same way, little tiny packet of land added to it, but always in my client's sole name. He owned it beforehand, and nothing happened during this marriage to affect that at all. And I'll come on very briefly at the end of my submission to deal with the wife's case in relation to Ardenside land. Ardenside business different, because the husband did grant shares in relation to that. And so on the basis that there's been matrimonialisation in relation to those shares, we'll deal with that in just a second, but in relation to Ardenside land, this judge saw that there was a clear dividing line. And if there's a clear dividing line, as Lord Justice Moylan says in Hart, there's no reason why that then shouldn't be applied in the discretionary stage. This is non-matrimonial property. Nothing has happened to affect the status of that. It should be left out of the sharing principle. But in relation to the Ardenside business of 8.6 million and the 80 million of transferred shares, what the judge did was say, well, I'm going to put all that together with other matrimonial property and divide that 60-40. Without any disrespect to the judge's experience in this field, we say, having found matrimonialization, it would have been better for him to adopt a more methodical approach to giving fair allowance, to try and find some solid ground. What he effectively did was look at all the other assets other than Ardenside land. So he deducted 20 million from the 132, leaving 112. He gave the husband the first 20% of it, 22 million pounds, and divided the rest 50-50. That's what he did. 22 million pounds to reflect an initial contribution of 57 million pounds back in 2004, we say is inadequate. The desirability of adopting some measure of intellectual rigour in relation to the identification of fair allowance is something that we collect from this court's decision in XW and XH. And I hope that's in your bundle now. Would you turn to paragraph 115, which is on in my bundle on page 441. It's on page 20 of the judgment. In addition, having regard to the judgment below in this case, I think I need to make clear that when I said in Hart that the court can undertake a broad evidential assessment when there is a complicated continuum and leave the specific determination of how the parties' wealth should be divided to the next stage, I did not mean that the court need not identify at the next stage, namely quantification of the award, how this factor impacted on the award. The court does not have to apply any particular mathematical or other specific methodology, Hart at paragraph 96, because as I said in Martin, there is no single route to determining what assets are marital. However, as I also said in Hart at paragraph 96, the court will have to decide what award of such lesser percentage than 50% makes fair allowance for the party's wealth, in part comprising or reflecting the product of non-marital endeavour. This can be a broad assessment, but when this is the only factor justifying a departure from equal sharing, the percentage division will inevitably make plain the court's decision, because otherwise, because, for example, by awarding the applicant 30% of the current wealth, it will be apparent that the court's broad assessment was that 40% of the wealth was not to be treated as matrimonial property. I return to this issue below. And also relevant, if I may just take you back up to 114, what is being undertaken is a retrospective analysis to determine by making, to repeat, fair overall allowance, or by giving the weight the court considers just, what part of the current value of the assets should be treated as matrimonial marital property for the purpose of the application of the sharing principle. So we submit that this court was not saying that it's an exercise that should be completely intuitive or instinctive. Some intellectual rigour to that exercise should be undertaken. At a mere £22 million or 10% departure, we say doesn't go far enough in itself, but also was the product of too intuitive and too instinctive an approach. Can I hand up a document that we prepared overnight just to illustrate what the judge might have done.
We got an X. Yep, Lady Shackleton needs one. Thank you.
This is really just putting in mathematical and numerical terms the submissions that are within our skeleton already in terms of where you might have got under various routes. And I call it the fair allowance calculations. At the top you see what the assets were. Moundsmere 20.6, the Ardenside land 20 million, the transferred assets 80 million, Ardenside business 8.6 and other 3.4. On the basis that you're allowed to stand the judge's findings of matrimonialization, we say that the proper categorisation of those assets is that Moundsmere and the other assets were matrimonial, Ardenside non-matrimonial, but in relation to the transferred assets and the Ardenside business, fair allowance needed to be made for the non-matrimonial element, the source, the fact that a large part of this wealth was seen to be generated, was definitely generated before the marriage. He could have adopted any of these routes. Excuse me. In Robertson, we know that Mr Justice Holman, in that case, adopted a half in, half out in relation to the complex continuum assets. And so if he were to do that, he would have ended up with Moundsmere being divided equally, nothing for Ardenside, the transferred assets half in, the Ardenside business half in, the other assets all in, a total matrimonial pool of 68.3, half of which is 34.2. He could have adopted the approach adopted by Mr Justice Mostyn in FZ and SZ, that is to look at deducting the historical value of the contribution. The consequence of that, Moundsmere in, Ardenside out, transferred assets down to 26.5. That's 80 million less 53.5, and the 53.5 is the 57 million less the value there attributable to Ardenside, because Ardenside is separately dealt with. Ardenside business in at full value because the judge didn't find that it had any historical value. Other assets 3.4, that would give an asset pool of 59 million, half of which 29.6 million. Or he could have adopted an approach analogous to the approach adopted in Martin and Martin in relation to the straight line. The total assets in this case were 132.6 million. They were the product of the husband's generation over a 50-year period from 1972 when he worked through to 2022. That's quite a generous period as far as the wife is concerned, because of course from 2007 onwards he wasn't working, he wasn't generating any wealth. But let's just, for the sake of argument, take a 50-year period. The period when these parties were cohabiting all the way through the trial was an 18 period. That gives 36%. The matrimonial element would then be 36% of 132.6 million, 47.7 million, and half of that is 23. We think that one of these sorts of routes might have given the judge a better route to a more intellectually rigorous and a fairer. And all of those, you see, are well below the 45 million that he allows this wife. All of those give proper weight. And we say that it is also important for the judge to, well, it would have been fair for the judge to take into account not just the 57 million brought in 2004, I do stress, in 2004, but the fact that that will have attracted very substantial passive growth. This was developed quite extensively before the judge below. It was uniquely primed to grow this wealth for two reasons. One, because of normal asset inflation, but also it was held in currencies that have strengthened massively against the pound.
Yeah.
by taking a historical value figure, the B below, that is making no allowance at all for passive growth. Now, my learned friend will say, yes, but within the 80 million, there was also some earnings, and we accept that the judge found that, although we can't see how that can be more than, say, £13 million of that 80 million. And not all of that, those earnings will have been saved. Some of that would have been spent in lifestyle as well. But passive growth, it's quite interesting, notwithstanding quite extensive submissions about passive growth before the judge and charts showing how things will have gone up. Passive growth doesn't get one mention in the judgment. And we say that that's perhaps another way in which this judge was underestimating the significance of this vital premarital, non-marital contribution. Now, self-evidently, in cases where there is a huge premarital or non-marital element, the ultimate share received by the other party is pretty small. And that's just the proper application of the sharing principles. So, for instance, in K&L, the husband got 9% of the overall wealth. In McCartney and Mills McCartney, the wife got 6% because of the gigantic. We have advocated, and we continue to advocate, that the right result for this wife was £25 million. That would give her some 18.5%. And we say that that's fair, bearing in mind. But if you find that matrimonialisation took place, but that insufficient fair allowance was made for the scale of the husband's historical premarital earnings and contribution, then the figure will be, we say, it may be above 25 million, but it can't be as much as 45 million. That has to be an inadequate fair allowance or an unfair allowance. Just finally on that point, if you're with us that there hasn't been matrimonialisation and that 25 million is the right figure, you will want to consider that this is sufficient to meet needs. It seems a fairly self-evident proposition that £25 million will meet the wife's needs. If you want to see a breakdown of how that proposition was justified before the judge below, that is in the supplementary bundle at pages 293 to 294. That's how we say the wife's needs properly assessed come to about £18.5 million. There's a buffer of nearly £7 million there.
Do
you want to see that?
I was just going to ask whether or not those representing the wife put in a comparable document.
Their case as to needs was that the wife needed, I think, £75 million. But I don't think anyone in this case wants this case to be remitted.
Well, that was my next question for both of you, actually, in turn.
Yeah.
In the event, well, first of all, in the event that it was determined that the judge was right to say that the £80 million became matrimonial property, but you succeeded on your submission that the quantum was wrong, would you seek to remit that, or would you ask the court to substitute?
Definitely the latter.
Right.
We would be in a situation then much like the XW and XH case.
And alternatively, if we determined that the judge had been wrong and that this was not, the 80 million was not a matrimonial asset, and therefore on your case it'd be a needs case, would you be asking for the matter to be remitted?
No, definitely not. As I say, we would say that the husband's figure of 25 million is manifestly sufficient for need, and that is something that is analysed at supplementary 293 to 294.
And you say that we could do that even though there's a gap of £50 million into what the wife says her needs are compared to your analysis is?
I would say that you're able to do
Thank you.
Where's her analysis in the written documents?
that. Her analysis, Mr Harvey can. 336. I'm grateful to my own friend.
Thank you.
Sorry. My lady, I'm going to go finally with Ardenside.
Sorry,
The
just
land.
give me
Wait a minute.
1 moment to just make sure I've got that flagged. And I can. Thank you. Well, that doesn't say 75 million, it says 54 million.
I might have exaggerated, I'm sorry about that.
Well, at least 54 million.
This is ground 2 of the wife's appeal. The wife raises 2 points, neither of which we say are sustainable. First, she suggests that the value of the land was increased not just by passive factors, but by active factors. And secondly, that the land should be treated as matrimonial because of the use made of it during the marriage. My lady, Mr Justice Moor deals with this fully at paragraph 67 of his judgment, which I think with my learned friend Mr Todd you had the opportunity to look through yesterday. But can I just also well, these findings were based on hearing the witnesses and also reading their statements and also reading the valuation evidence that was before the court. In respect to the wife's evidence concerning the Ardenside land, this was declared by the judge, you see at page 129, end of paragraph 66, to have been unsatisfactory. So it's little wonder that he rejected her false claim that the property had been a matrimonial home. It was not. It was a working farm, brought into the marriage by the husband, retained by him in his sole name, essentially the same operation that had been in 2004. Never merged, never matrimonialized or mixed in any way. It had been owned jointly with his first wife, but her share was transferred to him on his first divorce and then was never owned jointly with his wife. Moreover, the land was obviously a clear dividing line, non-matrimonial asset. As I say, this was different from the business because of the granting of the shares. The suggestion that the value of this land has increased by active factors rather than just property prices has no evidential basis. It had no evidential basis before Mr Justice Moor, and there's no evidential basis before this court. The additional 81 acres, hectares acquired, completely inconsequential. Some fencing was put up, but that was all burnt down. But we say it was the judge who was plainly in the best position to make the factual findings and to evaluate that on the evidence that was before him. He heard what the wife had to say and he rejected it, and there's just no identifiable error there. Those are my submissions to the court, unless I can help with any other point.
Thank you very much indeed, Mr Bishop. Now, Mr Todd, anything in reply?
My lady, yes, please. Lady, may I address that question which was raised a minute ago, which is the question of needs?
Yes.
Mr Justice Moor, of course, didn't dissent to deal with needs. He simply said
Understood.
£45 million would be enough, and that reference is at page 135. Within that difficult situation, how would the Court of Appeal deal with what is reasonable property need of the wife in the context of the wealth? What is the income needs of the parties? That was the subject of quite a lot of evidence before the court below, but not the subject of any findings. In those circumstances, we struggle to see how remission would be avoidable because it is an issue which is so live between the parties. Mr Justice Moor's, I had hoped that there was some opportunity to say within paragraph 85, well, he's saying 45 million is the needs. What he says is, I do not need to undertake a needs assessment, and it's quite clear to me that the wife can live very well on a sum of 45 million pounds. Of course, that means if your needs are £1, you can live within 45 million. So I had hoped that would avoid a remission, but I don't think it can do. So we think that is a difficulty. And
so that's if it was a
if it's
needs
case, if it becomes a needs case.
If, however, it was a case, was the percentage correct? What's your position on that?
Well, we would say in those circumstances that we would have argued for a needs case, as indeed we did do, but we recognise what Mr Justice Moor says, and it seems that our argument would therefore be our needs are at least or at the figure of £45 million. We can't go behind, we can't go back to the figure that we had put in our skeleton,
54,
which
minimum.
is 54 million.
Yeah.
Because Mr Justice Moor has said no, it's not above 45 million, and we would have to accept that finding of fact. But we would say 45 million is the needs figure, and so therefore the percentage would have to be on that, because as my learned Lord Justice Moylan said, needs is going to trump the sharing case. My Lords, one of the primary disputes between us seems to be whether or not the origin of an asset is more important than the ownership of it. And that, in a nutshell, is what this case focuses on. A great deal of time was spent by both my known friend and I as to whether or not ownership or title, which is the same thing, title entitles you to ownership, is a relevant part of the process. My known friend says no, not at all. We say absolutely it is. And we are very, very different when it comes to the role that title or ownership must play in the discharge of the function of the court's powers. As a matter of practice, we referred to in opening, the ES2 table, which is now mandatory in the financial remedy cases, produces 3 columns for the husband, 3 columns for the wife. The husband contends what he owns, what the wife owns, and what is joint. If there's a dispute about it, it's found in the parallel 3 columns, where the other party says what they say is owned by the husband and wife, and what is owned jointly. That is effectively the foundation stone upon which all these financial remedy cases are determined, and it's ownership that deals with them. I'm going to come to it's not terra firma, what my known friend says, it's quicksand when he says, oh no, it's provenance of money, it's generation, it's not ownership at all. That is a far, far more difficult evidential concept to get on top of. And that's not what people do. People don't set out in those tables anything more than what the ownership is now. They might want to argue as to why it might be dealt with differently. In 99% of these cases, they say, well, our needs are such that one of the other columns should be invaded. But that view, that starting view, where we're completely apart, is where, with the greatest respect to my known friend, he's simply wrong. The foundation is what the parties own. And one of the reasons why this table is not very helpful is in not one of those cases was it the wife owning those assets, unlike this case. We're fortified in this view about that, but by section 25. I'm slightly embarrassed to be in the Court of Appeal referring to cases like White and actually go back to section 25 of the Matrimonial Causes Act, because
it's frankly a relief. Sometimes people seem to forget section 25 exists
well,
at all.
True, but it is the foundation, and we are apart on the foundation stone, where we say my left friend has terra firma, we say it's quicksand, we say ignore all those rhetorical devices. Look at the Act. I don't know if my lady and my lords have a copy to hand of the Act. We have some spare copies if that will assist. Section 25. Just section 25. Sorry. It might be easier if I just simply hand them up.
Thank you, Mr. Sear.
My own copy from. Do you need a copy of section? And it's just the section 25 itself that we return to.
Thank you. Such an old friend.
It is indeed. It's discretionary eminent, of course, comes in the second part, but it begins by saying at 25.1, it shall be the duty of the court in deciding whether to exercise its powers under sections, and then it is with the financial remedy sections above, and if so, in what manner. So, well, it must start from ownership then. It's because it has to decide, is it going to exercise its powers at all? What are the scenarios that Mr Justice
Look
Moor...
at section 24, don't you? Because it's
I mean,
different
25.
I'm sorry?
Section 25.1.
Yes, but this is only dealing with exercising the powers under section 24. And it's section 24 which deals with the property issue.
This deals... I don't know what my learned friend has hand. It deals with all the powers. Matters to which the court should have regard in deciding how to exercise powers under sections 23, 24, 24A, 24B.
I think my lord's point is that you're taking us to property rights and saying that they're the foundation. And what my lord's saying is, well, when we look at section 24, that tells us what you can do with property rights.
Yes,
and
yes, it does.
therefore, that presupposes that someone's considered what the property rights are.
Absolutely.
I think
Yes,
it
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 is.
also defines it also says what the property rights in question are,
Yes,
and it's rights in possession or in reversion.
quite. Absolutely. And it's also found within...
It's not actually title, it's possession.
Well, possession might be something valuable, and of course, this is an extraordinary piece of legislation designed to deal with everything from the local authority tenancy to the multi-billionaires, and so questions of possession then become very important, particularly if you have when this was passed, of course, you still had, in fact, even before this, you had 1977 Rent Act, tenancies, and so on. So questions of possession of...
We had social housing.
And social housing, absolutely. It's perhaps slightly depressing that it's a less significant part of these cases, but that it really was absolutely everything. But you had to start from somewhere. You had to say, well, what do the parties possess? What do the parties own? What do the parties have? And the idea that in English law, ownership is not important is a frightening concept. One of the possibilities that was postulated by Mr Justice Moor is, he said, well, this wife wouldn't have had much of a claim if it ended after 6 months. Well, that's right on the facts of this marriage if it ended 6 months, although, of course, she would have had an impressive needs claim as the child was born 6 days after the marriage and so on. But what if we put the exact facts of this case? What if, in the first 6 months of marriage, a husband gives, and I'm going to grab a figure out of the air, husband gives to his new wife £5 million. Apparently, he doesn't give it to her at all. That's the basis of what Moylan and Friends case is. She's got to pay it back. Well, that's going to come as a bit of a shock, and only because she was married. If they've been living together and he gave her the £5 million, and she gets to keep it, that would be extraordinary departure from what the parties would understand to be their ownership. And returning to section 25, though, one again of the matters which the court has to have regard to is under 25.1, when it says, if so, in what manner, to have regard to all the circumstances of the case. It's within all the circumstances of the case, that catch-all phrase, that a lot of the modern jurisprudence has developed. It's within that we find things such as the source of the assets, because we're looking in vain for it to be elsewhere. And the reference to contribution that is found within section 25.2f is specifically insofar as it relates to the marital partnership. So coming to 25.2, 25.2 is specific matters the court should have regard to in relation to a party to marriage. The court shall in particular have regard to the following matters, and I'm going to come back to A, just picking up F, which is where contributions are referred to. Contributions which each of the parties has made or is likely in the foreseeable future to make to the welfare of the family, including any contribution by looking after the home or caring for the family. So the express contribution that's referred to is contribution to marital partnership. Going back to 25.2a, the court must expressly have regard, in relation to a party marriage, the court shall in particular have regard to the following matters. A, the income, earning capacity. property and other financial resources. Property. That's what kills my learned friend's submissions stone dead, because it's property at the time of the financial remedy. He cannot, no matter how skillfully he has attempted to do so, he cannot go behind the finding that this legally beneficiary was the property of the wife. So how does he depart from it? Well, he introduces this extraordinary idea that it's not property at all, it's a generation thing. His generation concept is the heart of how he puts his case. He says, time and again, it's not the owner that matters. And I wrote this down. In fact, I went back over the transcript to find it. It's to find out what his actual phrase is. It's the person who generated. That's the test that my learned friends are inviting you to do, apart from overturning KNL in paragraph 18b. They're inviting you to say that the test should not be that one that's found within the Matrimonial Causes Act, but you should look to the person who generated the property. Yesterday, my Lord Justice Moylan raised the difficulties that might arise in a situation where the parties have agreed how they're going to hold property and so on. And yes, every property ownership matter is pregnant with the possibility of dispute. That's always possible. In the vast majority of cases, it doesn't happen. But that is as nothing compared to the extraordinary nightmare that will be visited on people when they say, we're not interested in the ownership of property. What we're interested in is how it's generated. And this case is a very good example of how impossible what my learned friend says. And when I say it's impossible, I'm adopting the findings of Mr Justice Moor. He says it's impossible. And one of those matters that my learned friend didn't take you to was how the case was put in response to the argument that the money was all generated by the husband. He shrugs it off. He says, oh, well, you know, there's not really any argument about this because we opened the case on the basis that it was all the husband's. Mr Justice Moor did not make any findings in their favour. Indeed, one of the matters that my learned friend said today is plainly contrary to the finding. He said, oh, well, there was only $13 million of earnings that went in.
Pounds.
Well, that's $13 million. Well, that's totally contrary to paragraph 82 at page 135. In paragraph 82 at 135, the judge says, on any view, he earned around $40 million gross during that period. Well, that's
Well, I think in fairness, what Mr Bishop said about that, now you've seen the transcript, I haven't, but I think what he said is that if it was $40 million, by the time you dealt with tax, did you say CGT, and then converted it into sterling,
yes,
that was the equivalent to roughly
Yes.
13
and it was the most
million pounds. So I don't think he, my understanding, and do correct me if I'm wrong, is that he wasn't actually going behind your
I see.
oft repeated $40 million. He was simply saying, let's turn that into a comparable when we're talking about 80 million pounds. I think that's what.
Yes. Well, that in itself emphasises the point that I'm making, which is the impossibility of this generation game that's being undertaken here. What is being said is, we say Mr Justice Moor is in effect saying it's at least 40 million gross. I don't know what the tax is. There was no evidence of the tax. My learned friend makes submissions about it. But it's quite interesting what the case was before the judge. And that was page 333 in the supplemental bundle. And it gives an idea of just how impossible an exercise this is as opposed to ownership. It's page 333. And it's subparagraph 5, right at the bottom of the page. And one of the things, it's not right the husband was shown. We spent most of the cross-examination, in fact, dealing with this, these sorts of questions, certainly, or a great deal of it, dealing with these questions of what the husband had had. and indeed documents that we were discovering during the process, such as from the earlier divorce. So paragraph 5, what did he have in 2002, 2003? And this was, of course, related to, we were saying, the relationship.
Sorry, I think I may be in the wrong place. I'm at 333.
333, paragraph 5, right at the bottom.
Supplementary bundle.
As a supplemental bundle, yes.
I'm the wrong 333. Apparently there's 233. Let me try
Are
again.
there?
There are. All right.
I don't know how that's happened.
No, it's because one's the trial one. It's got it, paragraph 5 at the bottom. What do we have?
Paragraph 5, and this is in the title of factual matters.
Yeah.
So these are part of the evaluative exercise that is taking place here. And we begin to say, well, what did the husband have? Because we took the date of the relationship as being from the date of the engagement, and although Mr Justice Moor found the date of engagement was as the wife had said, he didn't date the marital partnership as being from when he took later. But that's why it was done in these terms. So we begin to say, well, unusually, and of course in the vast majority of cases, we're not going to have information going back 21 years, but we did have figures going back to 2003, because turning over the page at 334, we had the husband's divorce proceedings, and we were able to extrapolate from that what the husband had. And so we knew in May of 2002, when he sets off to his new job, he's worth, at exchange rates at that time.
Sorry to interrupt, but I'm just not quite sure where this is going in reply, because we have your point.
Yes.
That in reply, which is that actually it's even more complicated, because how do you start to do this?
Yes.
And even the judge at 80, whatever it was, didn't even attempt it, despite a large portion of the cross-examination being directed toward. I don't think going into the detail.
No. I was just saying it's impossible. And may I just give one or two very quick examples, and I'll move straight on. £94 million is how much the husband says is due just to foreign exchange. £94 million. The reference for that is page 319 in the supplemental bundle. Foreign exchange in itself, as we explain at 334, is almost impossible to look at. One remembers the famous example of Harold Wilson in the 1960s, when he devalued the pound, which is what has happened, and he famously said the pound in your pocket isn't worth anything less. And of course it was, because his purchasing power had disappeared. That kind of evaluation has to take place. If you're saying, well, there's a 94 million change because of foreign exchange rates, you then have to look at what purchasing power is. It's hopeless. My lady, if your ladyship is feeling this is exasperating, it's because it is exasperating. It's an impossible exercise to undertake.
So are you saying source is irrelevant?
We are saying that source, well, nothing is irrelevant because all the circumstances of the case have to be taken into account.
So where if you're looking at the scale of weight, does source and ownership stand?
Well, in a particular case, they have to be balanced between the two. So in the case which I was giving the example of, the 6-month marriage where the husband has gifted £5 million to the wife, then we say overwhelmingly the fact of the gift defeats the source, and the source counts for nothing at all. Because that's clearly what the husband intended, and the court should give effect to the autonomy of the parties.
So the weight to be applied to source and ownership depends on the facts of the case.
No, not ownership. Source it does, not ownership. So ownership, we say, is the foundation stone in all cases.
But sorry, I don't understand. If you're balancing it,
yes,
there has to be differential weight. You can't apply the same weight to one half of the balance, otherwise it's not a balance.
Source and ownership aren't always in contradistinction.
No, but I'm just saying, you were saying that the case is about origin, i.e. source, more important than ownership. And I'm just trying to understand what your case is on how they balance out. But I thought it depends on the facts of the case. But you were saying
it does depend on the facts of the case, exactly. So in a case such as this, we say that having started from the position of ownership, which means the wife has that separate property, the husband has that separate property, and so on, then it depends on which of those two tracks that one then goes down. Because if you go down the route of saying the husband gave the money to the wife in 2017 in her capacity as a partner of the marriage, then that is a partnership asset. And so we would say it results in it being a 50-50 divide.
Sorry, gave it as a,
Gave it to the wife in her capacity as a partner of the marriage. I'm picking up my Lord Justice Phillips' point. Then it ends up as being divided 50-50, and it's subsumed within that ideal. The source in this case is the source as of the date.
if you give it to somebody in their capacity as a partner to the marriage,
Yes,
and the marriage ends the next day,
yes.
what impact does that have?
It's become matrimonialized. It's going to be 50-50.
Because it's capacity at the moment, not the capacity that might endure.
It's
The length of the marriage has no impact at all on this.
if you are making gifts to someone, then that if you're making a gift outright to a person as an individual, it's theirs. If you're making it to the matrimonial partnership, then it's 50-50. Is what we're
Because you
saying.
see, when you said in her capacity as a partner to the marriage,
Yes.
one might add in her capacity as a partner to the marriage, which it is anticipated will endure.
No, most commercial
So
partnerships are expected.
This is given with the expectation that the marriage might end the next day. That doesn't matter.
It doesn't. All marriages, all partnerships can end the next day. It's a case of what's in the partnership. One of the
So I'm just asking you about the balance, and the balance will depend on things like is it given to the other spouse in their capacity as a partner to the marriage.
and that question of source also becomes absolutely critical, because it's no longer being sourced by the husband if it's not his. If he's divested all interest in it, it's no longer his.
He's no longer the source.
Yes. So let's take the example, which interestingly is not dissimilar to a case I'm involved in, which is whereby money goes to a third party. Let's say the husband gives his 77 million to a brother of his. The brother then says, for whatever reason, I'm already fabulously wealthy, but I don't like you, the husband. I really don't like you at all, but I do like the wife. So I'm going to give her the 77 million. Now, on my learned friends approach, that would mean, because the original source was the husband, it all comes back into account, notwithstanding that that's something the brother expressly didn't want to have happen. It means that spouses are reduced to some inferior class when it comes to receiving gifts. And it's so redolent with danger if you elevate the source to beyond that of ownership, which is how it's put in this particular case.
That's why I was asking about balance.
Yes.
It sounds like your submission is ownership always trumps source. Because you were saying it's dangerous if you elevate source above ownership.
Yes.
And I was sorry to ask again, but I don't understand if it's a balance, how that might not happen in some cases.
Well, I'm trying to adopt the Section 25 approach of never saying never. In the vast majority of cases, we say it's the ownership is going to be determinative on this sharing type of case. Obviously, in these cases, it's going to be different. So the original provenance of the money is not going to feature.
But then I'm sorry to keep asking questions, but what then happens in your ownership is determinative, source is irrelevant, if the moneymaker keeps all the wealth in their hands?
And if they keep all the money in their hands as their own separate property,
Ownership is determinative, yes?
yes, then it becomes a case of whether or not you have a need to claim against that money,
Right.
whether or not that money has been moved to the matrimonial partnership, which I assume it has not on my lord's example.
I'm just asking you, the moneymakers kept it all in their hands.
The money makers got pre-existing money. They've kept it all in the.
Sorry, I'm testing your submission.
Yes.
Ownership is determinative
It is.
in all cases.
It's not possible to say there are never exceptions because of the breadth of Section 25, but I cannot think of an exception standing here on my feet. So the separate property that the husband has in that example.
No, I didn't say separate property, whatever
Yeah.
that means.
Well, it is separate property.
No,
if it's in his own name.
Right. Okay.
So if he has properties separate from the partnership.
No,
Then
you're introducing different concepts. I was just
You
testing
could
your
say-
ownership is determinative.
Yes.
That was your submission.
Yes.
I'm describing it, I'm afraid to say, as a bald submission.
Yes, but it then depends exactly of whether or not the ownership as described is really the husband's ownership or whether or not it's partnership.
Right.
And that's a critical difference. So take the illustration of
And what decides whether it's partnership or not?
well
That source?
that exactly. And so if the husband earns money during the marriage, then that is going to be within the partnership. So that is partnership money owned by the partnership.
So that is an example of the source trumping, I'm using that word, overriding, being more significant than.
I don't think you're saying
Ownership.
that at all. I think
I'm
you're
not saying that at all. I'm saying
you
it becomes
really are
owned by
saying-
the partnership.
No,
Exactly.
What
I'm
you're saying is it's owned by the partnership.
Exactly.
And so really the source doesn't matter. It was generated during the course of what you
Absolutely.
the marriage partnership,
Right.
and therefore it's owned by the partners.
Absolutely.
Regardless
it's in
of
the
whose
third column.
name it is.
Well,
Yes.
when
I think
it,
Mr. Todd says yes.
yes, because the aim is the matrimonial partnership. It's the product. One of the questions which I can perhaps deal with by way of footnote is your lordship asked about where do you ever hear the expression community of property, and I can answer.
I didn't. I asked where you ever hear partnership marriage.
Partnership marriage. I see. Well,
I think community of property was yesterday.
yes. Okay. Well, we can leave that. So the perhaps one of the best illustrations of the difficulty of trying to deal with it on the basis of generation of wealth is that Mr Justice Moor, despite all this evidence, couldn't do it. And we still don't know what it is. We certainly don't begin to accept my learned friend's approach saying, oh, well, it's 13 million. That wasn't a finding. It was asked for to be a finding. It wasn't. Mr Justice Moor said, I just cannot do this. And he didn't actually need to. It
Mr.
said,
Todd, we are in reply. May I remind
indeed,
you, please?
I will be. Well, let me go very quickly. It said, well, we're departing from White and we're trying to go back to the old Court of Appeal approach. No, it's the husband who is trying to depart from White and go back to the old Court of Appeal approach. If one looks at White very, which is a 406E in the bundle of authorities, we can see they adopt exactly the approach that we describe when they start by saying, well, what are the assets here?
Sorry, can you tell me the page again?
Page 406, please, my lord. And it's letter E on page 406, or 601E in the law book. And
Sorry, which letter again?
we're looking at letter E. So the court of the House of Lords, letter E, when they're summarising the assets that they have available for distribution, they say these are the assets. This comprised on the figures found and used by the judge, Mrs. White's sole property. We're going to say that's the same as her separate property, but her sole property, or 193,300. Her share of property owned jointly, either directly or through the partnership. Well, that's reference partnership there as the farming partnership, but it would be equally true of the marital partnership. 1,334,000. Mr. White's share of jointly owned property, 1,334,000. And then Mr. White's sole property, 1.783 million. That was Rexton Farm. And it was being his separate property because he kept the ownership of it. The complaint of Mrs. White, and that's reflected in the Court of Appeal's decision, is that the Rexton Farm, which was said to be the husband's separate property, in fact was undertaken as part of their partnership. And where they say that the court went into error, which was the part that my learned friend referred to at page 416, it's because they tried to work out, the Court of Appeal tried to work out, 416 from letter D onwards, the Court of Appeal tried to work out exactly what went on, what were the contributions, what was the source of the money in Rexton. And it's that they were criticised for, and it was a case of where they were looking at the partnership interests within Rexton Farm and this argument about milk quotas and all that sort of thing, then that ought not to be dominating the overall picture. That would not be the total outcome for the proprietorial interest. So minuscule attempts to try and work out the source, which is what this is, are not to be encouraged. Not only are they immensely expensive, they're almost, as in this case, impossible to achieve. And the next point my learned friend says is partnership is just endeavour. We don't agree with that. I'm going to be about another 10, 15 minutes at most, my lady. The description of a partnership as just the endeavour must be wrong. A partnership, whether it's a marital partnership or a commercial partnership, is that which is within the partnership. My Lord Phillips was plainly right when he said, if someone gifts something to the husband and wife, if say a friend, a mutual friend of both of theirs from university says, oh, it's your wedding anniversary and I'm fabulously wealthy, have this extremely expensive gift. That's a gift to the partnership. And so it becomes part of the partnership. It's not just the endeavour. It's, as Baroness Hale rightly described it, the fruits of the partnership. When a partnership ends, any partnership ends, you divide up everything that's within the partnership. That's the fruit of the partnership. And it can include more than just endeavour, although endeavour is a key part of it. And we say absent need, should the non-matrimonial property ordinarily remain with its owner or the person who generated it, then it should remain with its owner. Because the alternative position, and it has to be my learned friend's submission, is that this gift, which was intended to have an impact on third parties, arguably everybody, because it had an impact on the tax. It may have been done for reasons that were good for the family, but not necessarily good for everybody else. It was certainly a gift that was intended to influence third parties, affect third parties. They say no importance whatsoever, and that's why all their cases don't refer to it. So we say matrimonial partnership is broader than just, for example, income or endeavour that's earned within it. It's also things that are put within that partnership, like it would be in a commercial partnership. Two commercial partners might decide to do that. And we say, when it comes to looking at a source, it is most helpful to look at the immediate source of the financial remedy case. And in that, ownership is critical. The interesting question that was raised is if the husband had used a different vehicle for moving the money in 2017, there would be no such as he gave it to his brother or gave it to a trust that he'd alienated his own interest in completely. There'd be no question that he couldn't retrieve the money. The only way in which the money appears to be said it can be retrieved is that the Matrimonial Causes Act can be used as an engine to take money that belongs unquestionably to the wife, to take it off her. And we say that unless that is just confiscation, it has to be on a principal basis. And either way, those principal bases reach the same conclusion. Either if he would have lost the asset either way, why should he get it back just because it's the wife's? After all, he's relying on ownership when he says in 2017, this is mine. This is my particular asset, and so he can't say, well, ownership is significant in 2017, but it's not significant later, because it's the ownership in 2017 that facilitates everything, not any point about source. But if the argument is that the money was given to the wife in her capacity as wife, then it's given to her in her capacity as partner. It becomes a partnership. So when we refer to matrimonialization as a concept needs to be tamed or perhaps got rid of, it was in the context of Mr Justice Moor saying that it's a fourth column on that asset schedule, that it's a partnership asset which doesn't need to be divided 50-50. That was our reference to matrimonialization. Matrimonialization could also mean, though, and it's this that should be got rid of, money is placed within a matrimonial partnership. And that's what we respectfully say Lord Justice Wilson was referring to in paragraph 18 of KNL, and that's why 18B is correctly there and should inform one of the two possible outcomes. Either this is the wife's separate property and she agrees for whatever reason that it should then be matrimonialised, or alternatively it was matrimonialised when it was given to the wife in her capacity as partner. My lady, my lords, my ladies, my lords, I don't know if I can assist you much further. The only thing I'm being asked to mention is, of course, the husband understood the importance of the ownership of this because he spent £500,000 on pursuing a mistake argument. So he plainly did believe it was of some great significance too.
Thank you very much, Mr. Todd. Well, may I thank all of you very much indeed for all the hard work that's gone into the preparation of the case, the written submissions, the oral submissions, for all, as usual, the assistance from the juniors behind, and your instructing solicitors who prepared the excellent and very workable and manageable bundles, for which I'm grateful for whoever did those. You won't be surprised to hear that we're going to reserve our judgments. I can't tell you precisely when we will be handing them down. In due course, they'll be sent out in draft in the normal way. That's for typographical errors and minor factual infelicities. It's not an opportunity to re-argue, please. May I ask those who will be having carriage of the documents to please take special note of the embargo, which isn't that new now, but I think it's very important. It's important particularly in a case like this because it's a draft. It's not our concluded judgment, and it's most important for the parent, for the family, for the husband and wife, that those drafts are only seen by the people that absolutely need and are entitled to see them for the purposes of approving them to come to us. Anything else I hope we'll be able to deal with in writing. If there's any disputes between you about any outstanding matters, then we'd hope we'd be able to deal with those on paper. So unless there's anything else that we need to deal with, I'll thank you all very much indeed.
Thank you, Renee.
All rise, if able.